What if the most popular rifle in America, the AR-15, was said to have no protection under the Second Amendment? This isn't just an idea. It's actually being reviewed by the Supreme Court right now. The big question the court is looking at is simple. Does the Second Amendment protect the right to own AR-15s and their magazines? The court is thinking about this today. Let's explain what's happening in this important case. Before we get started, if you want to help this channel, please subscribe. Also, make sure YouTube hasn't removed your subscription without you knowing. I also want to thank today's sponsor, Patriot Gold Group. The Federal Reserve is now cutting interest rates, which means one thing: more money will be printed. We're also seeing problems in the job market. There are big worries about mortgage rates and mortgage problems, with online searches about these issues reaching 2008 levels. Big names in finance are warning that 2026 could be worse than anything we've seen before. All of this is happening while our national debt keeps growing and has now passed $38 trillion. On the other hand, gold has been doing well. Major banks are saying gold prices could hit $5,000 per ounce or even higher. Look, if you own guns, you already know that protecting yourself against uncertain times matters to you. When things get shaky, you want to protect yourself and what's important to you. Your money should be no different. You should protect that too. Patriot Gold Group helps Americans protect their retirement with real gold and silver that gets sent to your home or kept in a special retirement account with no lifetime fees. They help you move your retirement accounts into real, physical precious metals like gold and silver that you actually own. If you're interested, call the proud Americans at Patriot Gold Group today before it's too late. Mention Armed Scholar to get the best service from patriots who want to help other patriots. You can also call 888-581-3830 for your free investor guide to learn more about protecting your money with Patriot Gold Group. Now, as I said at the start, in this video, we're talking about an important rifle and magazine ban case that went before the Supreme Court and was discussed at their conference today. The main case I want to talk about is called Harrell versus Cook County. In this case, regular citizens and groups like the Second Amendment Foundation are fighting against Cook County's law. This law makes it illegal to sell, give away, or even own what they call assault weapons. The law names about 100 rifles specifically. It also bans guns that have certain features like pistol grips, folding stocks, muzzle brakes, and other parts. The people suing say this ban doesn't just control firearms. It makes illegal some of the most common and popular rifles in America, which should be protected by the Second Amendment. This case uses recent comments made by Justice Kavanaugh after the court refused to hear a rifle ban case last term. When they refused that case, Justice Kavanaugh said that very soon the court will need to hear a rifle ban case and deal with this issue. He said they would do this within a term or two. The people suing are pushing this Harrell case as the right case for the court to finally deal with this problem. Also, at the conference today, another case was being considered that deals with magazine bans. That's the California Duncan case. The Supreme Court had already looked at it once, sent it back to lower courts, and now it's back again. They're also pushing the Duncan case, the magazine ban case, to be heard by the Supreme Court to strike down state rifle bans. Here's how the rifle ban case got to the Supreme Court. Back in 2021, the rifle ban lawsuit was filed in federal court in Chicago. The people suing challenged the county's ban based on the Second Amendment. In 2024, while the case was still going on, Illinois passed a statewide assault weapon ban that covered the same ground as Cook County's rules. That new state law was called the Protect Illinois Communities Act, or PICA. We've talked about that law before. Around the same time, the Seventh Circuit Court decided a case called Bevis versus Naperville. They said Illinois' law was okay and claimed that AR-15s were too military-like to be protected weapons. They ruled that guns that are useful in military service could be completely banned. The district court had to follow the Seventh Circuit's ruling in the Bevis case. So they ruled in favor of Cook County and said the restrictions on these types of rifles were legal. They said these were assault weapons and could be banned because they're military-like. The district court ruled for Cook County. In 2025, right after the Supreme Court refused to hear the Snope petition, the Seventh Circuit looked at this Cook County case and agreed with the lower court. The Seventh Circuit heavily relied on the Bevis ruling, treating AR-15s as basically civilian versions of N16s and therefore not protected by the Second Amendment. Now the people suing are asking the United States Supreme Court to step in and solve this disagreement. They want the Supreme Court to decide once and for all whether Americans have the constitutional right to own AR-15s and similar semi-automatic rifles that states are now completely banning. The petition says that circuit courts are divided and very confused about how to apply Heller and Bruin, which are important Supreme Court decisions. Some courts say AR-15s are weapons, but can be banned anyway. Others say they're not weapons at all and therefore get no protection. The people suing say the Supreme Court needs to make clear that all firearms, including semi-automatic rifles, are weapons under the Constitution. In their Supreme Court petition, they include surveys, production numbers, and sales information to show that tens of millions of AR-15s are owned across America. They point out that these rifles are used for home defense, target shooting, hunting, and other legal purposes. They argue that if the Second Amendment doesn't protect these most widely owned rifles in the nation, then by that logic, no firearm is actually protected. Cook County has also filed their response to this case, which the Supreme Court is looking at during their conference. They argue that this case doesn't deserve the Supreme Court's attention for several reasons. First, they say there's no disagreement between different circuit courts. Since there's no split or conflict on this issue, the Supreme Court doesn't need to hear this case. They argue there's agreement among lower courts and circuit courts like the Ninth Circuit, First Circuit, Second Circuit, Fourth Circuit, and the Seventh Circuit. Since there's no conflict, they say the case should be rejected. Second, they claim this case is a poor choice because the people suing failed to follow some basic court rules. Cook County argues that the people suing were in such a rush to get to the Supreme Court that they didn't follow all the procedures. Finally, Cook County says the lower courts were correct in their decisions. Even if you ignore all the other issues, they say the lower courts were right that these AR-15s are dangerous and unusual weapons that are closely related to N16s. Therefore, they say, these rifles don't get Second Amendment protection. In short, they say this case has procedural problems, has already been legally settled in the lower courts, and isn't the right case for the court to look at these types of assault weapon bans again. At its heart, this case asks the Supreme Court to finally do what we've been asking them to do for years. Hear a state rifle ban case and hopefully strike it down. This case went to their conference today, December 5th. It went to the Supreme Court for review along with several other Second Amendment cases, like the California Duncan versus Sponta case, which deals with California's ban on magazines that hold more than 10 rounds. Duncan is a case that was already granted, sent back, and returned by the Supreme Court a few years ago after Bruin. But like other Second Amendment cases, it's now suddenly back in front of the Supreme Court after all these years because lower courts keep refusing to apply the proper Second Amendment analysis. In some ways, they're directly ignoring what the Supreme Court said in Bruin. They're not doing Second Amendment analysis correctly, and that has led to many cases making their way back to the Supreme Court. They all went to conference today, and now we'll wait to see how the Supreme Court handles these issues. Up to this point, the Supreme Court has avoided rifle and magazine ban cases like the plague. However, we'll know very soon whether Kavanaugh's promise that they will hear this issue within a term or two was actually true or just another empty promise from the Supreme Court. We're going to find out really soon if they'll keep avoiding these issues and let the lower courts continue to mess up when it comes to state rifle bans and state magazine bans. We'll now watch the next Supreme Court order list to see what the Supreme Court decides to do. On the order list, we would see something like a denial, a grant, or we would see nothing. Then we might see these cases relist for the next conference. That would mean they're pushing this out or they're going to think about it again at a new conference. That's what we'll be watching for over the coming weeks. As we get more information and as this develops more, I'll let you know. If you liked this video and want to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All those things help the algorithm. But as always, thank you all for your support. And never forget, this nation was built by armed scholars, and this nation will be kept strong by armed scholars.